Top story, a huge setback for Swiss pharma giant Novartis. The Supreme Court has dismissed its plea for patent for its anti-cancer drug Glivec. It stated that this drug failed the test of innovation under the Patent Act and repetitive patent was not permissible. It's priced at a whopping 1.2 lakhs for monthly dosage to treat a form of leukemia. Now, Novartis had been fighting this case in India for about 7 years now. India had in 2006 denied the patent on the grounds that it wasn't considered a new molecule, but an altered version of one of that had been around for 15 years. The generic version costs about 10,000 rupees a month.
The claim of Novartis was that Glivec is better stability, more soluble. So the Supreme Court said these things by themselves cannot constitute invention, and therefore no patent can be done.
But as far as nationally and internationally, does Novartis have any remedy, considering that they can go to WTO and appeal against this order?
See, the thing is, there is a difference between India and the other countries where Glivec has been patented, because the Glivec molecule has been patented by Novartis in '93 when product patents were there in those countries. In India, there were no product patents. So I don't think this can be challenged in that sense.
Great judgment. The court has correctly understood that 3D is vital for making sure that you have good quality, safe and efficacious drugs.
But what does it mean? Now the cancer patients across the world will be able to get cheaper drugs?
No, not all over the world. It depends on whether they have a patent system like ours, where you can actually make sure that these drugs are not patented. We have a special patent system that is because of 3D. We are asking other countries also to follow suit, and they should have 3D. But they can issue a compulsory license and get drugs from India, like they're getting antiretrovirals. So Indian companies will still be the source of generic drugs.
And Novartis' stock has fallen by over 4% post this verdict. What does this now mean? Let's find out more from our health editor Amrita Tripathi, joining us from our newsroom. Also with us from the Supreme Court, our legal correspondent Ashok Bagaria. Ashok, to you first, just explain to us what the court said while giving this landmark verdict of sorts.
Well, there are three takeaway points from the Supreme Court. Number one, that the Supreme Court has come to a finding that Glivec is not a new drug. Secondly, the Supreme Court has said that by whatever standards you apply to this particular drug, it does not meet the test of novelty and inventiveness. And thirdly, they have rejected Novartis' claim for a patent for their drug Glivec. In fact, Glivec is a anti-cancer drug which is very useful against blood cancer. But here in the Supreme Court, we saw that this matter reached the Supreme Court in 2011 against the orders of the Intellectual Property Appellate Board. Here, Novartis made out a case that Section 3D of the Indian Patent Act was wrong and they should be given a patent for Glivec. But today, the Supreme Court has come to a final conclusion that Section 3D of the Indian Patent Act, which says that patents can only be given to new products or new inventions, has been upheld, and in the Supreme Court has denied this patent for Glivec.
Amrita, just help us understand what this verdict means for cancer drugs and the prices at which they sell in India.
Ananya, this is something that is far-reaching in terms of this specific drug Glivec. The generic version that Cipla markets is the reportedly monthly the dosage would come to about 9,000 rupees, as opposed to, as we were saying earlier, this generic drug, the drug of Glivec would cost about 1,10,000 rupees per month. So the costs are significant. This is for a rare form of cancer, we should add, for a type of cancer called myeloid leukemia. But the verdict goes much beyond that, because we do know India's generic drug industry, which is valued about $25 billion, is of course involved in making copies of many of these drugs that are not under patent in India and selling them for much cheaper. So very important for countries like India, very important also, Ananya, for countries like Brazil, for countries like South Africa and countries in Southeast Asia, which can then sell these under various agreements to their own population. So India at some level is also called the pharmacy for the poor, because of the fact that these drugs are life-saving and available at a fraction of the cost that these global multinational big pharma companies sell them at. At the same time, we should point out the big pharma majors in the US, for example, are quite upset with the way things are going, and have been asking the US government to put pressure on the Indian government, calling these sort of laws protectionist, saying that India is not, essentially saying it's not fair play. But a very clear verdict from the Supreme Court, as Ashok is telling us today, in terms of this sort of modified molecule, upholding that Patent Appeals Board verdict from earlier.
All right, Amrita and Ashok, thanks to both of you for joining us with that. And as Amrita has been explaining, it's a verdict that could have far-reaching effects also on other drugs, possibly non-cancerous ones as well.